No, it's
Oh,
yeah,
there
it's
it is.
on now.
Okay.
It's streaming live now.
Okay. All right, Smith, you ready?
Yes.
All right, this is the state of Georgia versus Elliot Christopher Weidman. And this is 20 SC 174951. Today is February the 16th, 2021. I am appearing today via the Zoom teleconference platform, as well as the other participants in this particular hearing are also appearing via Zoom. However, we are also broadcasting via the court's YouTube live stream channel, and therefore we have satisfied our obligation to keep the public's business open and accessible to it. I understand this matter is on for a plea this morning. Our assistant district attorney is Ms. Michelle Sims, and Mr. Weidman is represented by Randy Williams. I am going to turn this matter over to you right now, Ms. Sims, and see, first of all, if you have any questions you'd like to ask Mr. Weidman regarding his waiver of his appearance in the courtroom, and all of us appearing via Zoom, and my signing the documents for everybody. So I'll turn it over to you, Ms. Sims.
All right, thank you, Your Honor. So, Mr. Weidman, have you discussed today's proceedings with your attorney?
Yes, ma'am.
And did he inform you that you had a right to be physically present in the courtroom?
Yes, ma'am.
I can't hear you.
Yes, ma'am.
All right, and you understand that we're not appearing in the courtroom today because of the coronavirus. And are you waiving your right to be physically present in the courtroom?
Yes, ma'am.
All right, and usually there is paperwork for you to sign, including the indictment. Do you waive an original signature on the indictment and authorize the court to sign it on your behalf?
Yes, ma'am.
And Mr. Williams, do you waive an original signature on the indictment and authorize the court to sign it on your behalf?
Yes.
All right, and Your Honor, the state also waives an original signature on the indictment and authorizes the court to sign it on its behalf.
Thank you.
All right, Mr. Weidman, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Would you please state your true, correct, and legal name?
Elliot Christopher Weidman.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medicine that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
30 years old, and I am in my senior year.
Senior year of college?
Yes, ma'am.
All right, so you're able to read, write, and understand the English language?
Yes, ma'am.
And do you understand that you're charged with the following offense, aggravated assault?
Yes, ma'am.
Right, and you understand that you have the right to plead either guilty or not guilty to this charge, and if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
All right, and have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
And are you satisfied with his services?
Yes, ma'am.
Mr. Williams, do you waive formal reading of the indictment and any potential defects?
Yes.
Mr. Weidman, has your attorney advised you of the minimum and maximum sentence for the charge you were pleading guilty to?
Yes, ma'am.
Right, an aggravated assault carries a maximum penalty of 20 years in prison. Do you understand that you are about to enter what is called a negotiated plea of guilty, which means that the state will recommend a sentence to the court?
Yes, ma'am.
You understand the court does not have to accept that recommendation. The court can sentence you to the maximum on the charge.
Yes, ma'am.
And I'm sorry, I need to correct the record. I misspoke. The defendant is actually pleading guilty to the misdemeanor offense of battery, which is code section 16-5-23.1. And that carries a maximum penalty of 12 months in jail. That is the recommendation that the state is making to the court to allow the defendant to plead to the lesser included of battery for 12 months on probation, no violent contact with the victim, Miss Linda Mata, M-A-T-A, and he is to complete a counseling session, which I believe has already been completed. The defense will submit paperwork to that effect. And do you understand that to be the recommendation agreed upon, Mr. Weidman?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used at hand sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of battery and indictment number 20 SC 174951?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand they have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right, thank you, sir. Your Honor, the defendant has no prior felony convictions. The state believes if the case went to trial, the facts would show that on December 3rd of 2019, at 1255 West Peachtree Street Northeast here in Atlanta and Fulton County, officer was dispatched to the Arts Center MARTA station in reference to an assault. When the officer arrived, he spoke with the victim, Linda Mata, M-A-T-A. Ms. Mata indicated that she and her former boyfriend had gotten into an altercation, which turned physical. She indicated that she was inside her vehicle and the defendant, her former boyfriend, was standing by the driver's side vehicle and they were talking. when she was getting ready to leave, she asked the defendant to move out of the way. At that time, the defendant reached into the vehicle and turned the car off. He grabbed her keys and threw them into the bushes. Ms. Mata then got out of the car, and she indicated the defendant ran towards her. He kicked her in the legs and threw her to the ground. And there was, the police were called. By the time the police arrived, the defendant had gotten into an unknown vehicle and left the scene. The victim, Ms. Mata, did have 2 scratches to the right side of her neck. And mentioned is that she also got a protective order against the defendant as a result of this incident. And this all occurred here in Fulton County. And that is everything from the state, Your Honor.
All right, thank you, Ms. Sims. Mr. Williams?
Yes, Your Honor. Mr. Whiteman is, as he alluded to, is finishing his last year in college. He has no prior felony convictions, no violent convictions of any sort. While Mr. Whiteman has, on the advice of counsel, decided to move forward with this plea, Your Honor, I would make sure that the court understands that Mr. Whiteman poses no threat to anyone, neither to Ms. Mata, who has indicated that she does not need a no contact provision placed against Mr. Whiteman, that there is no threat or fear of Mr. Whiteman, and that we would ask that the court consider accepting this plea with hopefully that upon completion of his counseling sessions, that the court will entertain the possibility of this probation terminating early. For Mr. Whiteman, like I said, he works, he has a good support system with his family, and has no priors at all. So that's my position, Your Honor.
All right. With regard to the early termination of probation, have you talked, Ms. Sims, have you talked to Mr. Williams about that?
No, we did not, Your Honor. And Your Honor, I'm sorry, first let me let you know, when you're ready to hear from her, Ms. Mata would like to make a statement to the court.
Okay.
Yeah, and I apologize, Ms. Sims, I was messaging you. If you can look in your messages.
Okay, I do see it. Okay.
All right, I'll hear from Ms. Mata.
Greetings, everybody. Give me a second. I just need to pull up the actual statement. Okay, I'm ready.
Go ahead.
Okay. Greetings to all members of the court. I hope that this finds you well. There are some things that we learn from different experiences in life, both bad and good. In my case, I learned to be aware of my surroundings, be alert of places I visit simply to make sure I wasn't going to be surprised by Elliot, because it has happened in the past. This also created a depression and fear of him because he's attacked me outside of my house, did stalk me at my daughter's school, followed me to my college parking lot, even waited outside my car door by my job parking lot. Due to this, I had sleepless nights because I'd always had to check my house in and out before going to bed. And while even in bed, I'd get up to just go check my windows. The state of depression and fear that this caused me had me staying at home and not work during the pandemic. I'd be thinking he'd be there watching, waiting to hurt me if I'd go anywhere or whoever I'd be with. I isolated myself from friends and family that was always there to hear me. My life changed a lot because of him. At one point, I wanted to change my phone number 7 years, move to another city, and that way I not be depressed and have depressed and have fear of coming out of my house or answering phone call threats. My daughter Ada saw one altercation between Elliot he always felt scared and feared that something would happen again. I just wish he stopped with the insults, the threats, and coming to my house unannounced. Seems that anger would take over his emotions and actions. Although he apologized several times and I accepted the apologies over again, he'd always find a way to argue and get physical with me. I told him several times to stop in our last fight, and this time it was at a parking lot where there were people walking by. Someone called emergency. I honestly felt scared and feared of my life that I slightly even peed myself that night. Just reminiscing that night brings tears to my eyes. I never wanted him to be in jail. I never wished him to any bad. This may be because I always saw the good in him and had hopes of him being less aggressive every time. I felt like I was doing time with him for the 5 months that he was incarcerated. I wish things didn't go that far to begin with. I'd pray for him and always wished him he'd count to 10 just so we could talk like civilized people. I simply had faith. Excuse me. I'm just shaking a little bit. I simply have faith that even the worst of him may change one day, so he doesn't do all the terrible things he did to me to the next woman he's with. For that, I want Elliot to attend anger management every week and provide internal growth achievement. I want him to continue college and achieve his degree, just as when we met. I want him to work since he is head of household. I say this so that he is busy enough to not come to the house unannounced. Just understand that these actions don't guarantee he will not hurt me or stop me. I just want peace as I come peacefully in solitude. I don't want fights. If Elliot wants to speak, then let that interest resemble with his action, not uninvited presence. Like I initially said, there are some things that we learn from different experiences in life, both bad and good. This experience definitely has been for both to each individually.
Okay, well, thank you very much. Ms.
January 31st. Yeah.
Okay. Ms. Mata, thank you very much. I appreciate it. Okay, is there anything further?
No.
Okay. All right, Mr. Weidman, I have just a few questions for you, sir. Did you understand the questions asked of you here today by the Assistant District Attorney?
I'm not gonna say I 100% understand them, but for the most part, yes.
All right, Mr. Williams, is there any further conversation that you and your client need to have so that we can make sure Mr. Weidman understands what he's doing today?
If I can get a second, if we can, let me just mute for a second, and I'll call him real quick.
Okay, and you do the same, Mr. Weidman, and we'll take a break.
Okay, thank you.
Okay. Just to while Samantha go, if we can go off that record.
Okay.
Okay. All right. Do we have Mr. White? Kathy, have you had any further comments?
He's
Yes,
on.
Judge. Yeah, I'm on.
Okay, wonderful. All right. So we're going to wait to finish this one up. There, look at you. And obviously I want to get to everything today. We have a couple of pleas that are, I know everybody's ready to go, but I'm particularly interested on Calvante Dallas. Having a conversation with that officer.
Okay, that is which position, Judge?
Position number 2.
Oh, that's the
I entered a specific show cause order today for a detective to be either on Zoom or in court.
okay, I did not get a copy of that order, Judge.
It's on the record.
Yeah. I know that my investigator has been trying to get the body cam video and the lineup procedure. Unfortunately, my investigator lives kind of like you do, Your Honor, up north of the city and has texted me that he is not going to be in today due to inclement weather. I've left him a voicemail or rather a text message, but I have not yet heard back from him. So I have really no information on this officer or on the body cam video or the recording of lineup procedure. I know we did request it last week, but we haven't seen it.
Okay, hang on just a second. I'm going to come back to that one. Mr. Williams, are we ready to go forward?
We are, Your Honor. If the court would just allow me to make a statement that one of the issues that concern Mr. Weidman is an issue that the district attorney's office is aware of, and that Mr. Weidman was a little taken back by the characterizations that were put before this court by Ms. Mata, in that we have sent to the ADA attempts by Ms. Mata to contact Mr. Weidman several times, even though he has attempted to stay away from her. And he was somewhat upset by the fact that the characterization of him, and he believes to be false, and that the DA's office has received evidence of her attempting to reach out to him. And so if the court—
Second, and let me make certain, I'm sorry, Ms. Williams, can you let me make certain that we're back on the record with Ms. Ingram?
Thank you, Judge, because I wasn't sure.
Okay, let's go back on the record in the Elliott Weidman matter. And I'm sorry, Mr. Williams, if you'll start over.
Sure, Your Honor. Mr. Weidman's concerns were that the statements by Ms. Mata were not factual statements, and that we have on up to the date of this plea have made the district attorney's office aware of Ms. Mata's continued attempts to reach out and contact Mr. Weidman, in knowing full well that Mr. Weidman was prohibited from initiating any contact with her. Immediately upon these contacts, Mr. Weidman made my office aware of it, and then we in turn made the district attorney's office aware of those contacts. And so Mr. Weidman, hearing certain allegations from Ms. Mata here for the first time, was a little taken back and had asked that he wanted to make the court aware that there is a alternative view than the one expressed by Ms. Mata under the circumstances, and that he has at no time reached out to her since being released from jail on bond, and has not violated any of his bonding conditions.
Okay.
With that, Your Honor, he's ready to proceed.
All right, Mr. Weidman, the question that I asked you, sir, was whether you understood the questions asked of you here today by the assistant district attorney.
Yes, ma'am.
And do you understand the rights you're giving up by entering your plea of guilty today?
Yes, ma'am.
You wish to go forward with this plea of guilty?
Yes, ma'am, I do.
All right. And are you satisfied with the services of your attorney?
Yes, ma'am.
Do you believe you've had enough time to discuss this case with Mr. Williams?
Yes, ma'am.
Okay. Believe you understand and appreciate what you're doing today?
Yes, ma'am.
Okay. I do find that Mr. Weidman is entering this plea willingly, freely, knowingly, and voluntarily. I do find that there's an adequate basis, in fact, for the reduced charge presented to the court. And I do accept the plea of guilty, and therefore on one count of battery, the court hereby sentences you to 12 months on probation. That you have, this was presented to me as no violent contact, but I don't see that you need to have any contact with Ms. Mata for the period of probation. So I'm going to put no contact with Ms. Mata, and that you, have you completed the counseling course? Are you still involved in it?
I'm still involved in it. It's going to be about 6 more months.
Okay. And that you complete that counseling course Upon your presentation of whatever paperwork is necessary to show that you have successfully completed it, at that point, your probation may be terminated.
Okay.
All right. Is there anything further?
No, ma'am.
Okay. Thank you, Ms. Mata. Thank you, Mr. Williams. Thank you, Ms. Sims. That concludes the matter.
Mr. Mr. Weidman, your attorney is going to give you your instructions to report to probation.
Okay, thank you.
Okay. And if you'll get me that paperwork filled out, I'll send it to probation.
Okay, thank you.
Thank you.
All right, thank you, Your Honor.
All right. Thank you. All are excused.
Thank you, Your Honor. Have a great day.
Okay. Thank you. All right. Let's, thanks, Mr. Williams. Let's go back to the calendar then, and let's begin with Catherine Also Brooks. Ms. Lubinsky, what's going on in that one?
Sorry, Your Honor. Miss Also Brooks is in fact on the calendar. She called me. I think she's the LG stylo. I'm not entirely sure.
Okay. I thought that was Mr. White.
Your Honor, this is a case which should, I believe, be resolved. It's a case I need to discuss with Mr. White with a view to trying to get it resolved. Alternatively, we're ready for trial.
Okay. Is there, how much time do you think you and Mr. White would need to talk about it? A couple of weeks?
2 weeks should do it fine, Your Honor. We can't resolve it in 2 weeks.
Okay. Mr. White, what did you think about that announcement?
Judge, I'm not certain that I'm going to ultimately be the assistant district attorney on this case because it is a family violence case and we're trying to sort through it.
There for a minute, Mr. White.
Okay, can you hear me now?
Yeah, no, you scared me when you started saying you didn't think you were going to be the, don't do that to me.
Okay, but yes, I can, I have reviewed the case briefly. I believe it is a case that either can be resolved by a plea or the state will be ready for trial at the first available trial calendar.
Does 2 weeks sound reasonable? I don't want Ms. Lubinsky having to chase down the right ADA.
I will have a set answer for Ms. Lubinsky before the end of this day, and 2 weeks is definitely reasonable
Okay,
for us to lock this in.
Don't think it's a family violence.
I didn't think it was either, except that it's listed as family violence in our system. So I just want to make sure that our records in the DA's office either catch up with reality or I just need to make sure that we have the right assistant district attorney dealing with this case, Ms. Levinsky.
If I may address the court, Your Honor, I did take a look at this case and it seems that it's charges family violence because they were roommates. And if there's no romantic relationship, which I did not perceive from the police report, then we are not taking it in the part of the domestic violence unit.
Okay.
Great. That resolves it. I'll handle it. We need 2 weeks.
Great. Done.
Thank you, Ms. Sims.
Thanks.
Thank you, Your Honor. May Miss Also Brooke be excused, Your Honor.
Of course, and thank you for being on, ma'am. Okay, that brings us back. Let's table Calvante for just one moment. I'm going to come back to that. Let's go to number 4. And we have pleas today on Ms. Aisha Davis.
So, Your Honor, this is my fault. I did not send the waiver of indictment. I should have sent the waiver of indictment a couple of weeks ago. I prepared it now and sent it to Ms. Davis, but it has not been signed yet and forwarded to the state. Okay. This is entirely my fault. Mr. White, The plan was for position 5 to be accused so that she could take a plea to misdemeanor probation on both positions 4 and 5. Does that meet with what you have in your records?
My announcement was, is that I understand the previous negotiations in this case. However, the district attorney has, by policy, is not allowing us to waive indictment or accusation for a period until the beginning of March. And the reason is so we can get so she and her staff, her senior staff, can get a handle on where we are. So I was going to request that we reset this until the beginning of March. And then I will be in a position to accuse the case that is now 20 CP 194-480. So Your Honor, I would ask, let's see, today is this, I don't know what calendar you have after the 1st of March. I'm not sure what the date is, but I would ask that this be reset to that date and we can deal with it at that point.
Okay, will that give you a chance to get Mr. White all the paperwork, Ms. Lubinsky?
Yes, Your Honor.
Okay, well, that sounds like a good plan. And is Ms. Davis on?
No, I don't believe she is.
Okay, well, we'll get her the Zoom link for early March and we'll reset. Thank y'all. Okay.
I recognize that voice.
And Clayton Moore, position 6 and 7, we've had messages from Ms. Lake and Mr. White. I hope you got those messages as well. She is not present. She's on leave. And so we'll get back to those as soon as we can, okay?
Okay. Kathy, do we have a 2 weeks? Is that going to be enough?
It's going to be probably, it could be 2 weeks.
2 weeks.
2 weeks. All right.
Okay.
Thank you.
All right. Number 9 is Aisha Bozeman.
And her attorney is on.
Yeah. Did I get something about her not being?
I see her. She was in court, but I see her square there.
Ms. Render?
Yes.
Did I get a message about Ms. Bozeman and weather or something?
Oh, I didn't get that.
Oh, there's Ms. Render.
Okay. Another Zoom. Apologies, Your Honor. I'm on another Zoom call in Henry County. I definitely apologize.
That's what I got. Sorry, I knew it was something.
Yes, Your Honor. I do represent Aisha Bozeman, Your Honor. She's been incarcerated continuously for about 18 months now. She was transferred from Coweta County. Henceforth, she was transferred to Douglasville, where she was given a year to serve on her probation. Then she was sent to Newton County. And her probation was closed when she did another, I believe, 90 days. To this point now, she's at Fulton County. It was aggravated assault, Your Honor. She was on bond for, but I believe she did miss a court day, FTA. I believe it was 2 or 3 years ago. I'm not exactly sure on the time she missed, the exact date she missed, Your Honor. At this time, Ms. Bozeman is going not guilty, but we would like to speak with the ADA about a possible resolution. We'll also be filing a bond motion in this case to get a reasonable bond placed. And I don't know what the calendar looks like as far as openings, but if you allow me to orally make that motion, I can also file it as well, Your Honor.
Okay.
Judge, could we reset this for, do we have room next week for the bond motion?
Kathy, can we do that? Can we put it on next Tuesday or Thursday?
Yeah, I'll put it on Tuesday.
Okay. So, Mr. Render, here's exactly what we're doing, I think. We're going to reset it to next Tuesday, but that will take your client's waiving her appearance.
Oh, you know what? I have one spot on Monday, jail Zoom, so I could put her on that one.
Okay, will that give you enough time, Mr. White?
Oh, yes, ma'am.
Okay. All right, well, Mr. Render, you won the lottery today, sort of, without any real benefit. Your client will be on Zoom on Monday. We'll hear bond at that time. Certainly, if so she's made a tour through the Douglasville jail,
Dui County,
jail,
Coweta County,
Fulton
just all
County.
over the Metro Atlanta area, Your Honor. So we're just trying to
Okay.
end her trip, Your Honor.
Okay. So, is there anything else out there?
I'm sorry.
Is there anything else out there?
No, Your Honor. There's nothing else. If that concludes my business, may I be excused?
Your Honor, if I may, before Mr. Render leaves, Mr. Render,
Yes.
my phone number is 404.
1 second, sir.
All right.
404
612
612
4886.
4886.
Correct. And my email
All right, I will
is,
contact you.
yeah, just call me and we can either discuss it or we can set a meeting to discuss it.
Sounds good. Thank you, sir.
All right. Thank you, sir.
All right.
Okay. We'll see you next week, Mr. Render.
See you, Judge. Thank you. Thank you, ma'am.
Okay, number 10 is Ronnie Calloway. Ms. Hawkins. Hey, Janie.
Judge.
Okay, you want to be heard on bond reconsideration on that one?
Yes, Judge.
Okay, Mr. White, are you ready to do that? Not this very second, but you prepared to go on that?
Yes, ma'am. I know that our victim, Danielle Sweeney, I don't know that they're on but they want to make a statement and be heard on the bond. And I'm not sure that they're on the call right now.
Okay.
I don't see them.
Anyone from Sweeney, is Ms. Sweeney or anyone from the Sweeney family on? Okay, we'll come back to that one. That's 10 and 11. Okay, number 12, Antoine Jones. Is that Mr. Abadi? Or is that Mr. White?
No, that'll be me, Judge.
Okay.
That's my case, Your Honor.
Okay, you want to be heard on bond today?
Yes, Your Honor.
Okay, we'll come back. Are you ready on that one, Mr. White?
I'm just trying to review my notes. Yes, Judge. That's another one where we have a witness, Ms. Sheena Abney, that we've notified, who she said she would like to make a statement to the court opposing bond, and I'll have to make sure that we get her on the call.
Okay.
Or at least attempt to.
Is Ms. Abney on, or anyone from the Abney family?
Mr. Porter.
Yes, this is Sheena.
Ma'am?
Yes, my name is Sheena Abney.
Okay, hang on, Ms. Abney.
Abney.
We'll get to that. And finally, number 13 is Kenneth Baldridge.
And Your Honor, that's my case. I would ask for a couple of weeks. We are trying to find a placement for Mr. Baldridge. And we're still working on it.
Okay. Is that satisfactory for the state?
Yes, Judge, that would be great.
Okay. All right.
And Your Honor, I have one matter that is not on the calendar, but I expected would have been, and that's State versus Jarrett Johnson, 20 SC 177076.
All right.
And Judge, the state will be entering a motion to null pros that case.
In that case, it's on the calendar.
What? Give me the case number again, please.
Yeah, please.
Wait.
20SC177076.
All
Did I
right.
miss that as being on the calendar?
Jamie, is that your case?
Jarrett Johnson.
Jarrett,
But that's
wait,
Janie's.
Yeah, I believe it is your case, Ms. Hawkins.
Uh-huh.
hold on. I'm sorry, I wasn't paying attention.
Hey,
Oh,
the state's moving to null process case, Ms. Hawkins.
well, we could have null prossed it if you'd been paying attention.
You still can null process it.
Okay.
I'm sorry, you had to have been paying attention earlier.
No, I heard null process. I just didn't know who was getting null process. I heard that part, Judge.
Okay.
So that gets rid of his probation case as well, correct?
Yeah, obviously. We won't
Yes,
be.
and
Okay.
okay, so he should be released from custody within like 72 hours.
So Ms.
Well-
Brown will do the do the probation and I'll do the null pros.
Okay.
I don't have that case on my calendar. Can you give me the name?
Well,
Well, hold on one. Oh, do you have the probation case there? I don't have it right in front of me, but I'll get it.
I don't have the probation case right in front of me either.
I'll send it to you. Just a
I
minute.
can find it, even though
Okay.
And Kathy, I have prepared a written motion in order. What's the best way for me to get that to you?
You really don't have to do that. All you have to do is say you want it null pros, and I'm going to sign your name on there. Once we're actually back into the courtroom as normal, then you'll put your name on there. But at this point, I'll sign your name and then the judge will sign her name and we'll be good to go.
Yes, ma'am. Thank you.
We will likely have that done by the end of the day.
Okay. I will reach out to his family members. Thank you, Mr. White.
Thank you, Mr. White.
Welcome, Ms. Hawkins.
Okay, well, Mr. White giveth, and now we need to talk about Mr. Dallas. And Mr. White, you're going to have to indulge me a little bit back on number 2 because this is an ongoing problem for some time. I personally entered an order back in January, maybe January. I don't have Odyssey up now, but I heard from one detective who essentially said, well, gee, that's not my job. That's somebody else's job. And that was after significant work trying to get the first detective in the courtroom. This has been a matter, I mean, it's clearly an old case, but it's also been a matter where for some time we have been trying to get certain body cam and certain video. And I thought we had finally wrapped our arms around it. And that's why I ordered this man to be either in the courtroom or on Zoom. Now I can understand weather and I have it myself. But I have a Zoom and I'm not understanding why this man could not appear via Zoom. So again, I don't want the weight of 2 or 3 years coming down on your shoulders when you're the 4th maybe ADA to have this case.
That's okay, Judge. I have pretty broad shoulders.
Okay, well then please help us then.
Yes, ma'am.
Let me jump on you before Ms. Lubinsky does. Help us. What can we do?
Okay, well, we have, as I understand it, we have basically 3 options. I'm going to go by my order of preference. I would prefer first option, since I am new to this, I'm going to beg the court's indulgence for 1 week so that I can get my investigator and myself, and we will subpoena this detective. Not that a subpoena will take any more precedence than the court's show cause order, but at least we can try again next Monday or Tuesday to try and have this detective in court to be heard on bond.
Okay, well, let me stop you right there before I hear any more options.
Okay.
Ms. Lubinsky, your client is out on bond, correct?
My client is out on bond.
Okay.
And I guess my question there is if the officer was made aware of the order, then he should have been here, irrespective.
I agree.
So what day are we talking about having his body in the courtroom in front of me?
Okay, Judge, and I had misunderstood, and I had not read carefully. Okay, so this defendant is on bond. So what is the purpose then, short of trial, of the video?
It's called discovery.
We've been trying to get this for, I don't know, I've had this docket since July 1st, 2018. And I can't say it was immediately then, but I think he was arrested in September of 2018. We've been trying to get it for at least a couple of years.
Okay.
And to answer your question, Mr. White, there are questions regarding the identification procedure, which I cannot deal with until I have all the discovery. I may well have to file a motion to suppress. I would prefer to do that with the necessary documentation so that we don't come to court on the motion to suppress and get told, oh yeah, there is a recording, but we didn't think it was a good idea to give it to you. Then there is a question of client statement. There was apparently one made by client. I'd actually like to see it or hear it before I decide whether I need to file a motion to suppress on it. Actually, this is the case we spoke about when I met with you.
It is. And as I said, we've been trying since that date to pry this information loose from APD, and we have not yet. And as I said on that date, and I'll reiterate here for the court, Judge, the remedy for discovery violations are if I am unable to get that information, which I am presumed by law, an irrebuttable presumption that I have access to that, and it comes in late, then the court has the option of simply excluding that information from either the motion hearing or the trial or both. So there is a remedy, and the remedy simply is for Ms. Levinsky to file her motions. And at that point, if the court then gives an order that, this information needs to be produced however many days before the motion hearing, and I fail to meet it, then the court will certainly be within its sound discretion to simply exclude that, in this case, the body cam and any statement that Mr. Dallas is alleged to have made. And certainly that's the remedy that's available. That is a just remedy in this case. And then if that information being excluded, the state still has a case, we'll go forward. And if the state doesn't, then of course we will be compelled to dismiss the case.
Kathy, when can do we have Monday or Tuesday? Both.
This would be on Tuesday if we're going to do it, because I don't have any more spaces on Monday at this point.
Okay, Samantha, can we go on the record, please, in this one?
Sure, Judge, I'm ready.
Okay. This is the state of Georgia versus Calvante Lamar Dallas. Today, this is 18 SC 161949. Today is February the 16th, 2021. Everyone in this particular case, including Mr. Dallas, are appearing via the Zoom teleconference platform. However, these proceedings are on YouTube. The court's YouTube live public access channel. This matter was set down today with a specific order directed to a Detective Henderson, I believe, to appear and show cause why certain evidence had not previously been produced. I personally drafted that order, signed that order, and entered that order. And while I don't have access to it right in front of me, my significant belief is that I fell short of saying that I had reached the bad faith point. However, it was put on today's calendar. The detective has not appeared. He had the ability, or he had the invitation at least, to be personally in the courtroom or to appear via Zoom. I thought I heard earlier when we were not on the record that he was unable to appear in the courtroom. And I will say that our courthouse opened late this morning because of the potential of frozen roads in Atlanta, Georgia. I thought I heard that he was having difficulty because of the weather, but I do put on the record right now that we're resetting this matter until Tuesday. If the detective does not show up at that point, does not have the evidence at that point, then I am going to declare bad faith in this matter and we'll go from there. I would
Very well.
entertain any motions to exclude. Okay?
Court pleases. Thank you, Your Honor.
Thank you, Judge.
I want Mr. Dallas, who I do believe is on the line. There he is. Mr. Dallas, I do want you to understand this, and a lot of statements have been made this morning that this is, we're going to deal with it next week, okay? Thank you for being on.
All right.
All right, thank you. That concludes the Dallas matter. Now let's move on to, we took care of Clayton. All right, I think, do we have, Mr. White, I think we have Ms. Sweeney. Didn't Ms. Sweeney say, didn't she step in? Was it Ms. Sweeney or Ms. Abney?
No, it was Ms. Abney, Your Honor, on position 12.
Okay, so on Ronnie Calloway, do we have Ms. Sweeney or Danielle Sweeney or anyone on behalf of the Sweeneys? Ms. White, do you know anything about it?
Sorry, Yana. She confirmed her attendance, but I don't see her on here unless she's one of the phone numbers at the bottom.
Okay. Is Ms. Danielle Sweeney? Can you hear me? Ms. Danielle Sweeney? Does anybody know where she is?
No, ma'am.
Okay. But she was sent the information?
Oh, yeah. She confirmed her attendance with me, Your Honor.
Okay. All right. Are you able to speak on her behalf in this one?
Let me just check. I'll get right back to you.
Okay. We've got the Calloway matter. We've got Antoine Jones. So we have those two matters remaining. And I know we have Ms. Abney. Do we want to go ahead and take up the Ms. Hawkins, I hate to put you off, but do we want to go ahead and take up the Antoine Jones matter?
It's no worries, Judge. Fine. I'm the first one off anyway, so I'm fine.
You want to go ahead with Antoine Jones, Ms. Lubinsky, Mr. White? You ready for that one?
Yes, Judge, as long as Ms. White is still with us, because she also is involved in the Antoine Jones matter.
I'll be here. Mr.
Okay.
Corprew and Ms. Abney were expected to make statements, and they are here.
Ms. Abner, okay. Then we're ready on the Antoine Jones matter, Your Honor.
You ready on that one, Ms. Lubinsky?
Yes, Your Honor.
Okay. Hang on just one second. You ready, Samantha?
Yes, Judge, I am.
Okay. All right. This is the state of Georgia versus Antoine Marquette Jones. This is 20 SC 176846. Today is the 16th of February, 2021. Everyone on today's, on this matter is appearing via the Zoom teleconference platform. I should say the Assistant District Attorney is in the courtroom, but I'm not in the courtroom. However, we are broadcasting, for lack of a better word, this matter via the court's YouTube live stream channel for the public's benefit. I will say that Mr. Jones is not present, and we probably need to check on that issue with counsel as to whether he waives his appearance to be in the courtroom or on Zoom. So the state of Georgia is represented in this matter by Mr. White, and Mr. Jones is represented by Ms. Jennifer Lubinsky. And at this time, I'm going to turn these proceedings over to Mr. White.
Ms. Lubinsky, have you discussed with Mr. Jones his absolute right to be present in person at this bond hearing?
I have.
And has he affirmatively waived his absolute right to be present at this bond hearing?
He has.
And ma'am, did you get that waiver in writing?
No.
Okay.
Telephonically.
Okay. Judge, I have no further questions for Ms. Lubinsky at this time.
All right. Ms. Lubinsky, would you like to go forward?
Yes, Your Honor. And Your Honor, Mr. Jones is 36 years of age. He is single, the father of one child, a girl aged 6 years. At the time of his arrest, he was working at a Greek restaurant called the Greek Euro, and he had been working there for 2 to 3 months. Prior to that, he was working at Duracell. He is Atlanta born, actually born at the Crawford Long Hospital. His dad was in the military. All his family are in the Georgia area. He attended Barwick High School. He obtained a GED. Your Honor, he has been in jail now since March the 25th of last year, some 372 days in custody. Hey, that doesn't make sense.
The calendar says 321, but I think you're saying just under a year.
Yeah, just under a year.
Okay.
He has been in custody. Your Honor, a commissioner from the Fulton County Board of Commissioners visited the jail a week ago and declared that the conditions
I object to the relevance of this, Your Honor.
All right. Well, I'm not quite sure what she was going to say, but the relevance, Ms. Lubinsky?
Is that the conditions in the jail are
Your Honor,
inhumane.
the conditions at the jail are not relevant to the granting or denying of a bond. In this case, nor is the amount of time that he's been in jail. Since the entire amount of time that he's been in jail, we have been subject to the COVID protocols imposed on us by the Supreme Court, and we have been unable to indict this case. They go to none of the IALTA factors and in fact have no relevance to this proceeding.
Okay, well, it seems a bit unfair that you were able to say all of that without letting Ms. Lubinsky say what you were objecting to. But I think, Ms. Lubinsky, you're telling me that the conditions have been pronounced inhumane.
Quite correct, Your Honor.
Okay, well, that's, Mr. White is correct that that's not one of the Ayala factors. It is a condition of, that the court is aware of. So please proceed. Not that it's inhumane, but the court is aware of the pandemic and its basic effects on our overall society. Go ahead.
Your Honor, so Mr. Jones does have close family ties. He is not a flight risk. He does have prior convictions. None of his prior convictions have any violence in them. His convictions going back about 20 years, Your Honor, or close to 20 years, 18 more accurately, are things like theft by taking, financial transaction card fraud, and his most recent offense was a 2016 terroristic threats. He is not a danger to the community, nor is he a threat of intimidating witnesses. This was a vehicle accident, Your Honor, which tragically, very tragically, resulted in 2 people dying, Your Honor. But he does not know the witnesses. He is not a threat in any way to the witnesses. I would suggest that any condition of his bond would require him not to drive a motor vehicle at all until the finalization of this case. Your Honor, I don't know what other conditions the court would require. I don't believe an ankle monitor would be necessary.
Let me ask you, has a couple of questions, Ms. Lubinsky. Has he had a bond hearing? And I apologize, I don't have access this moment to Odyssey.
I'm not sure that he actually has. Let's check. Let me try and check for a bond order per se.
And Kathy, I had also asked you whether you saw anything.
Yeah.
I don't, not mine.
He had a bond hearing on March 26th of 2020, no bond. Then April 28th, bond denied. So this will be his 3rd bond hearing.
Okay, so the March 26th bond motion would have been the bond motion that took place immediately on his arrest. Statutorily, the magistrate judge hearing that could not grant a bond because of the nature of the charges.
And Judge Brasher is the one who heard the second one.
The second one is a bond motion.
He denied it significant risk of committing a felony. That's what his reason was. And that was February 28th, 2020.
No, April 28th.
I mean, April. I keep saying February.
Okay.
April 28th, 2020.
Okay. Okay. My second question, Ms. Lubinsky, is where do you propose that Mr. Jones would live?
So Mr. Jones was living in his own apartment, a rented apartment, 9261 River Chase Way, Jonesboro, and the zip there is 30238. There is no reason why he cannot live on his own.
River Chase, what River Chase, what?
Way, Your Honor.
And where did you say that was located?
In Jonesboro.
And did you, and what was the zip code?
30238.
Okay. All right. And how do you know that apartment's still available? Is somebody else living there?
I don't know if that apartment is available per se, but there is no reason why he cannot live on his own.
Okay. Okay. You know anything about his driving record?
Your Honor, he has a DUI conviction from 2007 and a couple of convictions for driving while his license is suspended.
Okay.
From what I can see, 2007, 2009, and I think 2013, driving while license suspended.
Okay. Okay. And do you know anything about this? I don't know if the restaurant is still open or what his work situation might be.
Well, Your Honor, he's been locked up for a year. He would have to go out and try and find work.
Okay. Okay. Any family that you know of?
He's got lots of family, Your Honor. He's got a father, he's got a grandmother, he's got 2 uncles, and I think I've spoken to the grandmother and the father.
All right, thank you. Mr. White?
Judge, at this time, it may be most beneficial for the court to hear from Ms. Abney.
All right. Well, I will hear from Ms. Abney. If you think this is the time, it's your case.
Well, Judge, at this point, the state's presentation is going to go directly to the first IOLA factor, flight risk, and the second one, given this defendant's considerable felony record and his past history of driving without a license while license suspended, basically his disregard for the rules of the road, there is a substantial risk of him committing an additional felony and creating an additional danger to the community, which is the third IOLA factor. And so that's where the presentation will go. And I believe that Ms. Abney and what she has to say will probably go to that, as well what Mr. Corprew has to say. And I believe he's on the call now.
Okay, Ms. Abney?
Yes, ma'am.
Hey, this is Judge Barwick, what would you like to say, ma'am?
Well, I had prepared a statement, so I wouldn't get too emotional. I'm sorry. Okay, I'm gonna read. I would like to oppose the bond for Antoine.
Your Honor, I can read her statement if it helps her. Miss Abney, are you going to be okay, or do you want me to read your statement?
I'm sorry. No, I'm gonna read it. I apologize.
Okay.
The accident that occurred last year took the lives of 2 people, including my mother. Due to the seriousness and severity of this crime, the accused should not be allowed to get out on release, even temporarily. Under the risk.
Ms. Abney, let me stop you for just a second, and I know how difficult this is. The problem
I'm sorry.
Ma'am, listen to me. The problem is that we've got 2 options here. I'm either more than happy to hear you read it, and I can kind of understand you, but our court reporter can't really hear you at all. And so we can either have you say what you want to say, but we aren't going to be able to have it in the record, or we can have Ms. White read it.
I apologize. Yes, Ms. White, if you could please. I apologize.
Okay, Ms. White, and Ms. Sweeney, please understand, I'm terribly sorry. It's just a matter of our technology. We just, between the phone and trying to hear things on the computer, we simply just can't hear you. Okay, Ms. White.
Okay. I would like to oppose bond for Antoine Jones. The accident that occurred last year took the lives of 2 people, including my mother. Due to the seriousness and severity of this crime, the accused should not be allowed to get out on release, even temporarily, under the risk of fleeing accountability of justice. We were horrified when we received the news of my mother's death on the 16th of February last year. Before the accident took place, she was traveling to assist another family member who was working late nights and didn't have transportation. To find out that she passed in such a painful manner was a devastating blow to myself and everyone in my family. To find out that this all occurred due to the recklessness of another was overwhelming. She was such a loving blessing to everyone she met, and her life was cut far too short. Due to the reckless actions that caused the crash, his repeated and risky behavior should be taken into consideration. The accident happened after the theft of a car and his careless driving. If there is no accountability, this increases the risk of similar actions repeated in the future. Sincerely, Sheena Abney.
Okay, thank you. Anything, Mr. White, is Mr. Corprew involved in this as well?
He is, Your Honor, and he is on the call. I believe he's got
I'm
video audio.
Okay, Mr. Corprew, is there anything that you would like to say to the court?
Yes. Am I being heard?
Yes, I can hear you. And
okay. I too oppose any type of bond for Antoine Jones. In talking with the arresting officers, or actually the officers who handled the case, when I was at the first court hearing, and Antoine Jones said that it was an accident, but never did he acknowledge the fact that 2 people lost their lives, nor did he apologize. And because he is a repeat offender, and according to the officer that I talked to from South Fulton County, they informed me that the car was stolen, that he was driving.
And Judge, at this stage, I must object. This is completely prejudicial. It is hearsay that is absolutely incorrect. There is no allegation whatsoever that the vehicle involved was stolen.
Okay.
I have a death report. Okay, well, let's say the car wasn't stolen. Let's say he didn't have a license, but he disregarded
hang on, just
Yes.
1 second. Let me go ahead and just address this on the record, because I want everybody to understand we're not here about the facts underlying whatever happened.
We seem to be hearing them, Your Honor.
That's why I'm talking about your objection right now.
Thank you, Your Honor.
The objection is we need to restrict ourselves to talking about just those issues related to Mr. Jones getting out on bond or not getting out on bond, as
Okay.
a flight risk, a danger to reoffend or intimidate witnesses. And so we have a very limited issue right now, and these facts that it's just natural to think in court, you want to talk about things. But counsel for Mr. Jones is correct, and I therefore sustain her objection. Mr. Corporate, tell me who are you speaking on behalf of? Is this also the same?
Felicia Nixon.
Ms. Nixon?
Which was my daughter.
Okay. Okay.
Well,
Mr. Corporal, you can read your statement if you'd like, because you addressed it in your statement. Why don't you stick with that?
If I can have Ms. White, if she can, just read the statement then, please.
Thank you, sir.
Okay. All righty. This is Mr. Corporal's statement. We are sending this email to you to petition the court and Honorable Judge Barwick to deny Antoine Jones bail. In the case that awaits trial relating to our daughter Felicia Monique Nixon, we counter his petition to the court, requested Judge Barwick deny Mr. Jones bail for the following reasons. Mr. Jones is a repeat offender, and it appears that he is still a danger to society by most recent acts that resulted in the death of our daughter and another innocent Georgia resident. Mr. Jones' actions on the night of the alleged incident, as recorded by the Fulton County Police Department, indicate that he acted in a reckless and blatant disregard for life. His acts of excessive speed, not obeying the traffic laws, further indicate that he has little regard for upholding the law and that he can potentially reoffend. Finally, our request is primarily rooted in the hope that by denying Mr. Jones' petition for bail, Fulton County will significantly increase the chances that no other family member will have to suffer such inexpressible pain and suffering as our family member has endured by his actions. Our daughter was fatally wounded just 3 days before her 32nd birthday, and as a result of his actions. Felicia leaves behind 3 young children that will now have to grow up without their mother. In addition to our loss, a loving mother was taken from her family while conducting a routine shopping trip to Walmart as a result of Mr. Jones' illegal actions. That is excessive speeding, running a traffic light, driving without a valid license, etc. Thank you we appreciate that last part is for me, so I'm so sorry. I'll just end it there, Your Honor.
Okay. All right. Thank you very much. Is there anything else, Mr. White? Is there anything else from the
Your Honor.
Yes, no, ma'am.
Yes,
okay.
There's no further evidence, but I believe that the statements and presentations of these 2 witnesses drive home the point that this defendant is, in fact, a significant risk of committing other felonies and additional felonies, and that he does pose a very significant danger to the community should he be released on bond. Judge, he has as the defense counsel pointed out, an 18-year history of disregarding not only the laws regarding personal property, including theft, and a very significant history of disregarding the safety of those who are on the streets and roads of Fulton County, as his traffic record it was brought out in detail by the defense counsel and by both of these witnesses. For those two reasons, the defendant does clearly fail factors 2 and 3 of the Ayala factors, and therefore the state does oppose bond in this matter.
All right, thank you. Ms. Lubinsky, I'll let you conclude.
Your Honor, I don't want to go into the facts of this case. I don't believe they are relevant for the bond motion. But I would point out that Ms. Nixon and the defendant were occupants of the same vehicle.
Okay.
And Your Honor, Mr. Antoine Dixon, I noticed, is on the line too. He is also a relative. I didn't know if he wanted to speak or not. He did send me a statement. I just picked it up late last night or early this morning, but it basically is covering some of the statements that have already been made.
Okay. Okay. Anything else, Ms. Lubinsky?
No, Your Honor.
All right. Let me first of all just express my sincerest condolences for those of you on the line who are on the call today who lost loved ones. That's number one. Number two, I'm unfortunately not able to give you a decision right now. I've got just a couple of things to research on this, and then I will get something out as soon as I can. So thank you very much. I appreciate it.
Thank you, Your Honor.
Thank
you, Your Honor.
Thank you. All right, and I think we've got one more, and that is, Jackie, what is that?
Item 10, Your Honor. Ronnie Calloway.
Oh yeah, Ms. Hawkins. Sorry about that.
And Ms. Sweeney is currently on the call, Judge.
Okay. Okay, are we taking up both matters?
Judge, I believe the motion for bond reconsideration is as to both matters. The state will only have a factual presentation as to 19 SC 169723, where Ms. Sweeney will make a statement regarding bond in that case. And then we will address the Ayala factors on both cases.
Okay. Samantha, are you ready?
Yes, Judge, I am.
All right. This is the state of Georgia versus Ronnie DeMonte Calloway. There are two case numbers. One is 19 SC 169723. The second is 20 SC 174213. And today is February 16th, 2021. This case is all being heard exclusively online on the teleconference platform, although I will note that the Assistant District Attorney in this case, Mr. White, is present in courtroom 8A, but everybody else, including me, are appearing via Zoom except for Mr. Calloway. We'll get to that in just a moment. I would like to state on the record, however, that this matter is being broadcast on the court's YouTube live stream channel to satisfy our obligation to keep the public's business open and accessible to it. These matters are on for bond reconsideration in each case. Mr. Calloway is not present, certainly not present in court and not present via Zoom. So I will begin by turning this matter over to Mr. White to see if he has any questions of counsel for the defense, Ms. Hawkins, with regard to Mr. Calloway's presence this morning. Mr. White.
Thank you, Your Honor. Ms. Hawkins, have you informed Mr. Calloway of his absolute right to appear in person in court at this bond hearing?
Yes.
And has Mr. Callaway, understanding his absolute rights, freely and voluntarily waived that absolute right to be here for this bond hearing?
Yes.
And ma'am, did you get that waiver in writing?
No, I got it in person and over the telephone several times.
Thank you, ma'am. I have no further questions, Your Honor.
All right, Ms. Hawkins.
Yes, Judge. Good morning, all. So Mr. Callaway is on today's calendar for a reconsideration of bond, and I want to kind of go through the history of procedural history of these cases. But first, Mr. Callaway is 22 years old. He is from Atlanta. He born and raised here, has been here all his life. He has several family members that are here. His mother's here, his father's here, his grandmother's here. And I've had contact with all of those individuals throughout the course of these cases and Mr. Callaway sitting in custody, with the exception of his grandmother. But Mr. Callaway is charged in 19 SC 169723 with theft by receiving and an expired license. Your Honor, my understanding is this is a June 26, 2019 incident date. And Mr. Callaway was given a bond in that case. On August 6th, 2019, theft by receiving, he received a $3,000 bond. And then the no license, he received a $1,000 signature bond. I believe we heard this case on February 27th, 2020, where Your Honor denied bond or denied the opportunity to reinstate his bond, because he did post his bond, he was released. In that case, I never received any discovery until February 12th of 2020. My understanding, and if I remember correctly, this case, Mr. Callaway's cases, has been on 2 previous status calendars for discovery issues. It appeared on the April 30th, 2020 status calendar, and it also appeared on the 7/16/2020 status calendar. And I was told that I would get discovery, and I never received discovery.
Your Honor, at this point, I'm going to object. While discovery issues are very serious, they are not relevant to a bond hearing.
This is a reconsideration, Your Honor. I am proving why you should reconsider bond at this point in time.
And Judge, for bond reconsideration, any discovery issues are not relevant.
I believe it is a significant change in his position, Your Honor.
That's not relevant for bond, Your Honor.
Under what authority, Mr. White?
Your Honor, both the case law and the statute clearly set out 4 factors for bond. None of those factors is discovery. It's simply the 4 IOLA factors, and discovery issues don't go to his dangerousness, his ties to the community, the likelihood that he'll reoffend, or whether he will influence or attempt to influence witnesses.
Well, I
Simply not relevant.
I guess my question really, Mr. White, was you said that you said somewhat definitively that discovery was not an issue in a bond, and I just wondered whether you had some case that said that.
No, Judge, it's just simply not in either the statute or in any of the criteria set forth in any case law that I'm aware of in consideration of bond. Discovery is a separate issue, and while it is a very serious issue, and while I understand Ms. Hawkins' frustration in that a year is a long time to wait for information from the state, and I would even go so far as to say it's an inexcusably long time. That doesn't go to whether or not Ronnie DeMonte Callaway is, in fact, a good candidate for bond, especially when his previous bond has been revoked for a new felony offense.
Oh,
Well, Your Honor,
hang on. You want to, I think we can move on, but do you want to, what is it, Ms. Hawkins?
we can certainly move on, but before we move on, I have to argue to you that there is some sort of change in circumstance. So as a part of arguing there is a change in Mr. Callaway's circumstance, I need you to understand that Mr. Callaway has been in custody for 508 days, and I was supposed to be given discovery by a case management order that Your Honor signed, issuing that or indicating that discovery needed to be given to me by a certain date, and it was not. So he has a part of his change in circumstance is that he's been sitting for almost 2 years, and I don't have discovery. I can't defend my client with this discovery.
Okay. All right. What's next?
Okay. So, and speaking to the Ayala factors, he was given a bond. Theft by receiving, he was given a $3,000 bond. He was given a $1,000 bond for the expired license.
Okay. You said I denied reinstatement of the bond. Was that because of did he fail to appear, or was that because of the new case?
His bond was revoked because of the new case.
Okay.
So we had to have it reinstated for him to be released.
Okay.
And then, Your Honor, going on to the next case, which is 20 SC 174213, where Mr. Callaway is charged with robbery, possession of a firearm during the commission of a felony, theft by receiving, obstruction, possession of a firearm by a convicted felon. This incident stems from an alleged September 26, 2019 incident. Again, we're working our way towards 2 years. However, he did have a bond. He satisfied the Ayala factors because a judge granted him a bond on September 28th. He was given a $5,000 bond for theft by receiving, a $5,000 bond for possession of a firearm during the commission of a felony, a $5,000 bond for the cruelty to children, a no bond status for the robbery, a $5,000 bond for the possession of a firearm by a convicted felon, and a $5,000 bond for obstruction of a law enforcement officer, which totaled to be $25,000. The only thing that was keeping him was the robbery. He was in a no bond status. And then on February 27th, 2020, Your Honor, denied bond. Your Honor, we're almost a year after that bond was denied. I don't have discovery, the rest of the discovery for this case as well. And he's been sitting, Your Honor. Discovery was due to me pre-pandemic.
Your Honor,
coronavirus.
I'm going to renew my objection to this. Appears to be a complaint, not even a motion about discovery, simply a complaint about discovery, which has no relevance to a bond hearing at all. A change in circumstance may have some relevance to the fact that a defendant cannot post the bond that was originally set. Even at that point, lack of discovery is not one of the factors in consideration for a change of circumstance.
And Your Honor, jail.
This defense counsel's presentation has no relevance to the motion before the court.
And pretrial jail is not supposed to be used as a punishment towards my client, who is cloaked with the presumption of innocence until he goes to trial. We don't know when he's going to trial. I don't have discovery. I can't file motions. He's just sitting in jail being punished for a crime he's not been convicted of.
And there is no evidence to support that, Judge.
Let me ask you this.
Except that he's been there for 508 days.
Let me ask you this, Ms. Hawkins. When is the last time, and I do not intend this question to suggest that the court has ruled that it is relevant, but have we had a hearing on discovery?
Yes, Judge. We talked about discovery on 4/30/2020. We talked about discovery issues again on 7/16/2020. I did not receive the discovery, the little bit of discovery for the theft by receiving case. I had nothing until February 12th, 2021.
Okay. All right. And did you receive everything or some?
No, I have the police report.
Okay. Okay.
Which I submit should have been available at the time my client was indicted.
And did we go over Mr. Callaway's history? I mean, I'm sure I did a year ago, but could you just do it one more time?
Yes, Judge. My understanding is that he doesn't have a criminal history because he's on first offender probation, which is another issue, which would be holding him. And Judge Downs, who's no longer on the bench, obviously, gave him sentenced him to first offender. On February 20th, 2018, he was sentenced to 5 years probation for robbery and cruelty to children.
Okay. Now, so obviously in the when this was indicted, and so it was just indicted, the cruelty to children seems to have dropped off.
Yes.
All right. Now,
I'm sorry. It wasn't just indicted. It was indicted shortly after he was arrested. It's been indicted since 2019 or 2020, early 2021 or 2020. Sorry.
I was just looking at the number on it. Okay. All right. Let me ask you this. How old is he? Did you tell me that?
He's 22.
You did tell me that. I'm sorry.
It's okay, Judge.
All right.
Good afternoon. I just have one thing to say. Ms. Hawkins, he does have probation out of Cobb County.
Okay.
And
I don't know, what conviction is that?
It's a theft by shoplifting. He was convicted on April 8th, 2019.
Okay, so that's after the, okay.
Is it felony or misdemeanor, Officer Brown?
It is felony. He received a 5-year probated sentence.
And does he have a hold out of Cobb?
I believe he does.
If it's not showing up, which I'll look, but if it's not showing up, it could pop up when he goes to get out. Sometimes that happens, but hold on, I'm getting up another audit.
All right, I've got, let me just tell you right now, and I apologize for this. I got some work to do on this one.
Understood, Judge, and I have an address to give you as well.
Okay, go ahead.
He would be living with his grandmother at 10352 Briar, BRIAR Bay Loop, and that's in Jonesboro, Georgia.
Did you say Briar Bay what?
Loop.
Okay.
And that's Jonesboro, Georgia, 30238.
Do you know his grandmother's name?
Her name is Sonia Callaway.
Okay. Do you know if anybody else lives there?
She just moved. I don't know if anyone else lives there.
All right. Let me do some work and I'll get an answer out as soon as I can.
Okay, Judge, I think you still have to listen to Mr. White. I don't know if he has more argument than what was already presented.
Judge, would you like to hear from Ms. Sweeney before we conclude the hearing?
Oh, I'm sorry. I'm sorry. Yes, I would. I apologize.
No, that's okay. Ms. Sweeney, are you still with us?
I am.
Okay. Ma'am, do you have a statement or another presentation you'd like to make to the court?
I've never done this before. I the name, his mother's name actually sounds familiar to me. I was just trying to look through some records to see if that was correct, because I think I actually had an issue with his mother before, if that's who I'm thinking of.
Okay, the woman whose name we just heard was his grandmother, ma'am.
Oh, I'm sorry, his grandmother. I'm trying to look through my pictures
Okay,
to see if.
Okay, do you have,
I don't understand how that's relevant.
yeah, Ms. Sweeney, do you have something to tell me about the bond issues?
Again, I've never done this before. I don't know what to say right now.
Okay, ma'am.
Excuse
Right
me,
now-
Miss Sweetie wasn't expected to give a statement today. She just wanted to be present.
Oh, okay.
So she
All right,
wasn't
ma'am.
prepared for that.
Okay. That's okay, ma'am. What we'll do is we'll have Miss White and I will talk with you probably later on this afternoon. Definitely Miss White will talk to you after this hearing.
Okay.
And then she can help you prepare a statement and we'll submit that to the judge, okay?
Okay.
Okay.
All right. Thank you, ma'am.
Thank you for being on, Ms. Sweeney. As I said, Ms. Hawkins, go ahead.
I was just gonna say, if that statement is to be presented to the judge, I would like to see it prior to, because I may have objections. And I won't have an opportunity to object if it goes directly to the judge, and I have a right to object if it.
Well, it wouldn't be presented unless it was presented as part of a hearing, Ms. Hawkins.
Well, let me just say this. There are a couple of things that can happen here. And I do think that if we're going to hold it open, then we need to hold it open. And Kathy, when is our next jail Zoom that has space?
Hold on. Uno momento. The 3rd, March 3rd.
2 weeks. What we can do is just adjourn at this point and reset it for March 3rd and have Mr. Calloway on Zoom from the jail. But actually, Janie, I know that puts it off a way, but I would almost rather do that, particularly if we're going to start having things said.
Okay, Judge.
Okay.
I understand.
Kathy, can you do that, please? And Ms. Sweeney, what we'll do is after you talk to, and we have Mr. White, which is spelled one way, and Miss White, our victim advocate, spelled another way. And so that will give you an opportunity to talk to both of them. And then it'll also give Mr. Calloway an opportunity to kind of see what's going on. So I realize it's 2 weeks off. And I'm mindful of everybody's time, particularly since we've been on a good bit today, but I want to do that.
Yes, Judge. Are you wanting to hear argument again, or just the alleged victim statement and see Mr. Calloway's face?
What I really want to do, yes, to all of that, and plus I want to go over my notes. And look at Odyssey.
Okay.
Odyssey, Ms. Sweeney, is our online docket that I don't have access to at this particular moment. I also would suggest to Ms. Hawkins and to Mr. White that this would give us an opportunity, since we have a 2-week delay, for y'all to kind of take a deep breath and maybe discuss some of these issues, because it does, I think Mr. White has demonstrated to me at least, that he's certainly mindful of what these kinds of problems bring up.
And I agree. I have no issue with Mr. White. Mr. White is walking into the disaster that is turning over discovery in a timely manner.
And Ms. Hawkins, if you can call me later on.
Yes.
We can discuss this, and I will do everything I can to make sure you get what you need, okay?
Appreciate that.
Thank you.
Mindful in our overall rubric that we're all operating under some stress. Also, 22 years young. Okay. So thank y'all very much.
Kathy has something to
Hold
say.
Whoa. So Jenny sent me a request for 2 cases that are those old CR cases that have been transferred to Superior Court, but we don't have a number yet. And these 2 don't have, we don't have a companion case.
Kathy, can we close the record in Callaway?
Yeah. Oh, yes.
Okay. And then I'm going to take us off.